Thank you very much first for allowing me to do the introduction for Ralph. And it is such a shame that I could not be with you in person, as I was planning to be in a previous event and was going to chair it. But now we've got definitely a much younger and more intelligent chair, and you'll have to put up with me giving the introduction. Let me just say who I am. My name is Izzat Darwazeh. I'm professor of engineering, of electronic engineering at UCL. I have been there 25 years. That is 2 years longer than Ralph, who many of you would know. He is the professor of international law at the Faculty of Laws at UCL, and he's been there 23 years. Ralph, modest as he is, and you will see, he is actually one of the world's leading academic experts on international law. He is not only an academic expert, he is also a practitioner of international law, and I'll just touch on this in a minute. He has done so many things that relate to law, international law. He actually served on the executive bodies of the American and the European Societies of International Law and the International Law Association. He held several visiting positions at different academic institutions worldwide, including Al-Quds University in Palestine, Georgetown University in Qatar, Harvard, and NYU, from the big to the small. And he was a Peace Fellow at the Uland Island Peace Institute. Next year, he will extend his wings and he will be a visiting professor at Yale Law School. The reason why I'm saying these things is it is such a privilege to have someone like Ralph as a professor at UCL, and I think, to give this talk. He is highly recognized internationally. He has got a book on international territorial administration published by Oxford University Press, and that was awarded the Booker Prize by the American Society of International Law. He is a leading global expert on Palestine and on international law, Palestine international law. He published extensively on the subject, including some of his publications, to name just a few, the Palestinian Book of International Law, and he has something in the Journal of the History of International Law. He is not only an academic, he actually practices what he preaches. He served as a legal advisor for the European Union and the UK-funded expert body to the PLO peace negotiators on internationalization and trusteeship, an important topic that probably he will address tonight. Being considered on trusteeship as being considered for peace agreement. And that was based on prize-winning the OUP book on these practices implemented in other places in the world. He also worked as a legal advisor to the Palestinian human rights NGO, to several Palestinian human rights NGO, including Al-Haq. Al-Haq, for those who do not know, is the main Palestinian NGO which is concerned with the human rights. And he was an advisor to it, and Al-Haq in Palestine, Al-Haq in Europe, and on the Jerusalem Consortium for Human Rights. He was a legal advisor to them. And last year, at the nomination of Al-Haq Palestine and the state of Palestine, he represented the 22 Arab states who are members of the League of Arab States in the advisory opinion case about the illegality of Israel's occupation of the Palestinian Gaza Strip and the West Bank and East Jerusalem, what's called the OPT. And he actually spoke, and his speech went viral, some of you may have seen it, at the International Court of Justice, or the ICJ. His central arguments, which is based on his academic work and publications, that the occupation is illegal. We might think that this is, you don't need an international law expert to tell you that the occupation is illegal, but actually you do, to know that it's illegal under international law. And Ralph has done a stellar job doing this. And that it is a violation of the Palestinian right to self-determination. And it is an illegal attempt to annex territory through the use of force. He has done a lot of work, and actually, as a result of, or one result of his work, is that legal judgment over illegality is now endorsed by the United Nations General Assembly. This year, Ralph represented Bolivia in the advisor opinion case before the same court, before the International Court of Justice, on the legal rights of states and international organizations enter and present in the occupied Palestinian territories to support the Palestinian people. He served as legal counsel to Bolivia at the emergency meeting of the Hague Group of States in Bogota in Colombia. Bear with me, I'll finish in a minute. Last year, importantly, he represented the Arab League and the Palestinian Human Rights Commission in the Palestinian case before the other international court in The Hague, the International Criminal Court, and the Gaza-based Palestine Center for Human Rights, NGO. His written submission is included in the South African submission in the genocide case against Israel before the International Court of Justice. Ralph has done so many things, so many academic things. He teaches international law and international humanitarian law at UCL, and as he did in many other universities. He practices it, as I've just said, and he researches it. For me, as a UCL professor, it is such a pride to have someone like Ralph with such an international acclaim to be a professor at UCL. That's for me as professor at UCL. For me as a Palestinian, it is also it is humbling to see someone like Ralph who defends the right of the Palestinians, not only because he understands international law. There are many people who claim to understand international law or practice it. It is because he actually believes in it. And he believes in the right of people to have decent and dignified life. I'll stop here. I'm so sorry I cannot be with you. I am sure you'd all enjoy and learn from this talk. And I'll listen for a little bit and then I'll disappear. Thank you very much, Ralph, for giving me the opportunity. And over to you.
Thank you very much, Izzat. If I can take a couple of minutes to say a couple of things about, I know you said that, then you have Ralph all to yourself. Okay, only because we go back many times, decades, don't we? And we go back more than 20 years. We both came to London from the provinces, at least in my place, so we were struggling to fit in, and we found each other. It was very, very nice early. And obviously, I was really impressed with this very bright, young, articulate international lawyer, for his command of the subject, his eloquence, fearless advocacy, always fearless. But so all of those things really impressed me. So it wasn't just your good looks and your senses, though that helped. But one special quality that I think he combines, and I think Izzat pointed out in different terms, but I give you the sort of jurisprudential version of it. So students of jurisprudence will recognize when I mention this sort of so-called long-standing battle between legal positivists and natural lawyers. And, the idea that, natural lawyers supposedly focus on what the law should be, on the justice, the morality of the law, whereas positive lawyers focus on what the law is, whether we like it or not, and we have to impose it. Well, Ralph is unusual because he combines both and manages to navigate both those areas. He can do both natural positive law, he can dissect it, he knows it by heart. He's able to appeal to it in minute detail, but at the same time, like Izzat said, he never loses sight of the cause behind the law, the justice behind it. So basically, like he's the lawyer you want to have on your side, as states like Bolivia and Arab League, who engaged him, know very well, and that's why he's been going viral ever since. And I do want to focus on his work on Palestine, which, as Izzat pointed out, started long before October 7. And what was really striking and disappointing for a lot of us, I'm a part-time theoretical international lawyer, is that how many of our colleagues, international lawyers, even those who call themselves critical or decolonial, took so long to put forward what was clear from the beginning, that Israel's action was not path of self-defense. In fact, a lot of our colleagues went public saying that this is self-defense, which obviously is a preposterous argument. You cannot defend something that you are legally occupying. Now, Ralph was one of the first to put it forward clearly and unequivocally And you had a lot of hate, including those of us who supported you. It was very so he was one of the first. And what's very special about Raf is that he's clear and unequivocal as to what is paramount and has been for the last 2 years and ever since. And what is paramount? He goes to the heart of the issue every time you hear him speak and doesn't let it go, because with or without the genocide, with or without but abuse of international law of self-defense, what's paramount is the Palestinian right to self-determination and the right of return. And what Raf never lets go of that, and he insists on not reducing it to a humanitarian issue, which a lot of our colleagues sometimes do. He repeatedly points out that it's not about this or that Israeli crime, it's all of it, because Israel has no right to be there in the first place. And also he manages, unlike me, to do this really coolly. I mean, I get really emotional when I talk about it, and sometimes, descend to despair. But he manages to forensically dissect the law and investigate the illegality and give you chapter and verse without all this feminine emotion or whatever. I just leave you with one of the quotes that I like. Izzat pointed out went viral when he gave his submission to the ICJ last year. And I will paraphrase a bit, because now we need to add to the legality not just Israel, but the Security Council, because they've come up with, as Rafkas will probably tell us more about, they have come up with a resolution that itself violates international law. So just to paraphrase Raf, Israel and the Security Council now cannot lawfully demand concessions on Palestinian rights as a precondition for ending the genocide, apartheid, occupation. Palestinian right to self-determination is absolute. Genocide, occupation, apartheid are existentially illegal and must end immediately. We all help. So we hear more on the...
Thank you very much for those very kind words to both. Now, as Izzat kindly mentioned, last year I had the great privilege to represent the Arab League in the advisory opinion case before the International Court of Justice on whether the Israeli occupation of the Palestinian Gaza Strip and West Bank, including East Jerusalem, was in and of itself lawful. And as was mentioned, my argument, which I'll explain today, based on my academic publications, that it is illegal, was adopted by the court in its landmark ruling and subsequently the UN General Assembly. And when Maria mentioned earlier Israel not having a right to be there in the first place, just to be clear, Maria was referring to no right to be in the West Bank and Gaza in the first place, not its to be there itself, its existence. Maria was not saying that.
No.
No, it's very clear.
I should leave, according to my...
To be there meaning the West Bank and Gaza. Okay.
Sorry, I'm just going to pop this in users just to make a little bit more sound.
Okay, so it's been easier to deploy my academic ideas in this way than to be an academic in the West and this country and this university generating the ideas in the first place. Hence, today is the first time I've ever presented these ideas in a UK university, including my own. And this event was, as been mentioned, cancelled more than once and is only happening after surmounting the most exceptional challenges. You being here today, then, is an act of defiance against efforts to suppress the expression and the reception of a particular position on Palestine. Not because you necessarily agree, but because you have a right to hear it, and, if you wish, oppose it in the Q&A session. I am so grateful to those who've enabled this, in some cases, in the face of considerable pressure. My own faculty, and in particular the Dean, Professor Eloise Scotford, and the wonderful faculty events manager, Lisa Penfold. The student volunteers, who I will not name to protect them, Izzat and Maria. To those people and to you, my greatest thanks. So, to the ideas they tried to ban, which I present in my personal capacity only. The Palestinian people have been denied the exercise of their legal right to self-determination through the more than century-long violent, colonial, racist effort to establish a nation-state exclusively for the Jewish people in the land of mandatory Palestine. When this began in earnest after the First World War, the Jewish population there was 11%. Forcibly implementing Zionism in this demographic context has necessarily involved the extermination or forced displacement of some of the non-Jewish Palestinian population, the exercise of domination over and subjugation, dispossession, and immiseration of remaining non-Jewish Palestinians, the emigration to that land of Jewish people, regardless of any direct personal link, and the denial of Palestinian refugees the right to return, all operating through a racist distinction privileging Jewish people over non-Jewish Palestinian people. This has necessitated serious violations of all the fundamental rules of international law apart from the prohibition of slavery, the right of self-determination, the prohibitions of aggression, genocide, crimes against humanity, racial discrimination generally, apartheid in particular, and torture, and the core protections of international humanitarian law. The legal right of the Palestinian people originates in the sacred trust obligations of Article 22 of the League of Nations Covenant, part of the Versailles Treaty. Palestine, an A-class mandate under British colonial rule, was, after the First World War, supposed to have its existence as an independent state provisionally recognised, a sui generis right of self-determination. The UK and other members of the League Council attempted to bypass this, incorporating the 1917 Balfour Declaration commitment to establishing a national home for the Jewish people in Palestine into the instrument stipulating how the mandate would be run. However, the Council had no legal power to bypass the covenant in this way. It acted ultra vires, and the relevant provisions were legally void. There was and is no legal basis in that mandate instrument for either a specifically Jewish state in Palestine or the UK's failure to discharge the sacred trust obligation to implement Palestinian self-determination. After the Second World War, a self-determination right applicable to colonial peoples generally crystallized in international law. For the Palestinian people, this essentially corresponded to and supplemented the pre-existing covenant right regarding the same single territorial unit. The 1947 proposal to partition Palestine into two states was contrary to this, the Arab rejection and affirmation of the legal status quo. In 1948, then, Palestine was, legally, a single territory with a single population enjoying a right of self-determination on a unitary, multi-ethnic, multi-racial, multi-religious basis. Despite this, a state of Israel, specifically for Jewish people, was proclaimed in 1948 by those controlling 78%, more than three-quarters, of Palestine, accompanied by the killing and forced displacement of a significant number of the non-Jewish Palestinian population, the Nakba catastrophe. There was no international legal basis for the creation of a state exclusively for one racial and religious group, the Jewish people, on land populated not only by members of this group, but also by non-Jewish Palestinian people. In particular, there was no legal basis for creating this state to protect the Jewish people from discrimination, displacement, and extermination in the light of the Holocaust. If this necessitated, as it did, discrimination, displacement, and extermination of the non-Jewish Palestinian population of the land in question. The Shoah did not justify the Nakba. There was and is no international legal rule requiring a non-European people, the Palestinian people, not responsible for the discrimination, displacement, and extermination of the Jewish people of Europe by other Europeans, to pay the price for this through their own discrimination, displacement, and extermination. The illegal secession involved in the proclamation of Israeli statehood was an egregious violation of Palestinian self-determination. This statehood was recognized and Israel admitted as a UN member despite this illegality. Israel is not the legal continuation or the successor to the mandate. This violation of Palestinian self-determination is ongoing and unresolved. Two key elements are, in the first place, Palestinian people not displaced from the land proclaimed to be of Israel in 1948 and their descendants have been forced to live as citizens, presently they constitute 17.2%, of a state conceived to be of and for another racial and religious group, under the domination of that group, necessarily treated as second class because of their race. In the second place, Palestinian people displaced from that land and their descendants are prevented from returning. These are serious breaches of the right of self-determination, the prohibitions of racial discrimination and apartheid, and the right of return. These serious violations must end immediately. As if the ongoing Nakba was not catastrophic enough, in 1967, Israel captured the remaining 22% of historic Palestine, the Gaza Strip and West Bank, including East Jerusalem, the Nakba. It has maintained that use of force to remain in control in what is, in consequence, called, as Izzat mentioned, the Occupied Palestinian Territory, the OPT, for the 57-year period since. For more than half a century then, a state defined to be of and for the Jewish people exclusively has governed the entire land of Palestine and the Palestinian people there. And the regime of racial domination, apartheid, and denying the right of return has been extended throughout. In the case of Palestinians living in the OPT, this has involved the same serious violations of international law, supplemented by serious violations of norms applicable in occupied territory. Indeed, these people are subject to an even more extreme form of racist domination, as they aren't even citizens of the state exercising authority over them. Even in East Jerusalem, which Israel has purported to annex, treats it as its own sovereign territory, the majority non-Jewish Palestinian residents are not given citizenship, whereas Jewish residents, including illegal settlers, are citizens. There have also been violations of many other areas of international human rights law in addition to the prohibitions of racial discrimination and apartheid, including the prohibition of torture, inhuman and degrading treatment, and violations of the core rules of international humanitarian law, crimes against humanity, and genocide. Just as in territorial Israel, in occupied territory, these serious violations concerned with how Israel exercises authority over the Palestinian people must end immediately. However, in the OPT, a more fundamental matter must also be addressed: the illegality of the exercise of authority itself. The enduring Palestinian legal right of self-determination means that the Palestinian people and the state of Palestine, not Israel, are sovereign over the territory Israel captured in 1967. For Israel, this land is extraterritorial and, given what I said about the mandate, territory over which it has no legal sovereign entitlement. Despite this, Israel has purported to annex East Jerusalem and taken various actions there and in the rest of the West Bank, constituting purported annexation, including implanting Jewish settlements. It is Israeli policy that Israel should be not only the exclusive authority over the entire land between the river and the sea, but also the exclusive sovereign authority there. This constitutes a complete repudiation of Palestinian self-determination as a legal right, since it empties the right entirely of any territorial content. Actualizing it through purported annexation is, first, a serious violation of Palestinian self-determination, and, second, a serious violation of the prohibition on the purported acquisition of territory through force in the law on the use of force, and so an aggression. It also involves some of those serious violations of the rules of international humanitarian law regulating the conduct of the occupation that I mentioned, the prohibitions on implanting settlements, and altering, unless absolutely prevented, the economic, legal, political, social, and religious status quo in occupied territory. As I had the privilege to argue before the ICJ last year and the court agreed, the occupation is therefore existentially illegal and illegal in its conduct because of its use to actualize purported annexation. To end this serious illegality, it must be terminated. Also, Israel must renounce all sovereignty claims and all settlements must be removed. However, this is not the only basis on which the occupation's existential legality must be addressed. It's also necessary to account for the law of self-determination and the law on the use of force. The right of self-determination, when applied to the Palestinian people in the territory Israel captured in 1967, is a right to be entirely self-governing, free from Israeli domination. Consequently, as I argued before the ICJ last year and the court agreed, the Palestinian people have a legal right to the immediate end of the occupation, and Israel has a correlative legal duty to immediately terminate the occupation. This right exists and operates simply and exclusively because the Palestinian people are entitled to it. It does not depend on others agreeing to its realization. It is a right. It's a repudiation of trusteeship, whereby colonial peoples were ostensibly to be granted freedom only if and when they were deemed ready because of their stage of development determined by the racist standard of civilization. The anti-colonial self-determination rule replaced this with a right based on the automatic, immediate entitlement of all peoples to freedom, without preconditions. In the words of United Nations General Assembly Resolution 1514, passed 65 years ago next month, and I quote, "Inadequacy of political, economic, social, or educational preparedness should never serve as a pretext for delaying independence." End of quote. Some suggest that the Palestinian people were offered and rejected deals that could have ended the occupation, and therefore Israel can maintain it pending a settlement. Even assuming arguendo the veracity of this account, the deals involved a further loss of the sovereign territory of the Palestinian people. Israel cannot lawfully demand concessions on Palestinian rights as the price for ending its impediment to Palestinian freedom. This would mean Israel using force to coerce the Palestinian people to give up some of their fundamental legal rights. Illegal in the law on the use of force, and I'll come back to this, necessarily voiding the relevant terms of any agreement reached. The Palestinian people are legally entitled to reject a further loss of land over which they have an exclusive, fundamental legal right. Any such rejection makes no difference to Israel's immediate legal obligation to end the occupation. Israel's exercise of control over the Palestinian territory since 1967 as a military occupation is an ongoing use of force. As such, its existential legality is determined by the international law on the use of force, as a general matter, beyond the specific issue of annexation. Israel captured the Gaza Strip and West Bank from, respectively, Egypt and Jordan in the war it launched against these two states and Syria. It claimed to be acting in self-defense, anticipating a non-immediately imminent armed attack. The war was over after 6 days. Peace treaties between Israel and Egypt and Jordan were subsequently adopted. Despite this, Israel maintained control of the territory, a continuation of the use of force enabling its capture. Israel's 1967 war was illegal in the law on the use of force. Even assuming arguendo its claim of a feared attack, states cannot lawfully use force in non-immediately imminent anticipatory self-defense. Moreover, again assuming arguendo that the war was lawful, the justification ended after 6 days. However, the requirements of the law on the use of force continued to apply to the occupation as itself a continuing use of force. In 1967, with self-determination well established in international law, states could not lawfully use force to retain control over a self-determination unit captured in war, unless the legal test justifying the initial use of force also justified, on the same basis, the use of force in retaining control. Moreover, this justification would need to continue not only in the immediate aftermath, but for more than half a century. Manifestly, this legal test is not met. Israel's exercise of control over the Gaza Strip and West Bank through the use of force has been illegal in the law on the use of force since the capture of the territory, or at least very soon afterwards. The occupation is, therefore, again existentially illegal in the law on the use of force, an aggression this time as a general matter, beyond illegality specific to purported annexation. To terminate this serious violation, the occupation must likewise end immediately. Israel's failure to end the occupation gives rise to a right in international law vested in the Palestinian people to violently resist. This right does not justify the intentional targeting of civilians or indiscriminate attacks that risk harming civilians or the kidnapping of civilians, all of which are illegal as outside what is permitted by the right itself, and also violations of international humanitarian law, international human rights law, and international criminal law. Israel's military action in Gaza hasn't stopped since the misnamed ceasefire. On that, I humbly quote UCL graduate Dr. Rafat Alaria, murdered by Israel in a strike in Gaza just under 2 years ago on the 6th of December 2023, to Dr. Alaria, for the Palestinian people, a ceasefire means we cease, you fire. And that military action didn't begin in October 2023. The genocide was a drastic scaling up of the force exercised in Gaza and in the West Bank on a continual basis since 1967. A justification for a new phase in an ongoing illegal use of force cannot be constructed solely out of the consequences of violent resistance to that illegal use of force, even when resistance goes beyond what is legally justified and is therefore itself unlawful. Otherwise, an illegal use of force would be rendered lawful because those subject to it violently resisted. Circular logic with a perverse outcome. There's no right of defense to defense. More generally, Israel cannot lawfully use force to control the Palestinian territory for security purposes, pending an agreement providing it with security guarantees. States can only lawfully use force outside their borders in extremely narrow circumstances. Beyond that, they must address security threats non-forcibly. Likewise, there is no rule of international law justifying the continuation of the occupation until there is a peace agreement meeting Israeli security needs. Such a rule would do away with the very operation of the fundamental legal rules of international law concerning self-determination and the limits of unlawful force that I outlined earlier. As a result, the matters that these rules conceive as rights vested in the Palestinian people would be realized only if agreement is reached and only on the basis of such agreement. At best, if an agreement is forthcoming, this would mean that it need not be compatible with Palestinian fundamental rights. It could be determined only by the acute power imbalance in Israel's favor. At worst, if no agreement is forthcoming, this would mean that the indefinite continuation of Israeli rule over the Palestinian people in the OPT on the basis of racist supremacy and a claim to sovereignty would be lawful. The Israel must agree before the occupation must end approach is an affront to the international rule of law and the United Nations Charter imperative that disputes should be adjusted and settled, and I quote, in conformity with the principles of justice and international law, end of quote. The plan for an international trusteeship over Gaza, run by Donald Trump and Tony Blair, purportedly authorized by United Nations Security Council Resolution 2803, passed on Monday last week on the 17th of November, would also, if implemented, violate international law. The Palestinian right of self-determination as it applies in the OPT, including Gaza, is a right to be self-governing as a general matter, self-rule rather than rule by another actor, any other outside actor. Substituting Israeli occupation with occupation by another is a violation of self-determination. Whether or not the other actor is less abusive than Israel and the trusteeship is temporary is irrelevant. Any agreement provided by the representatives of the Palestinian people would not alter this illegality. Agreements brought about through an unlawful use of force, as this one would be, and contrary to fundamental and so peremptory non-derogable rules of international law, as this one is, self-determination has that status, are void. The Palestinian people have been here before with the Oslo Accords. As I argued for the Arab League before the ICJ and the ICC last year, such agreements may be in force insofar as they are compatible with the peremptory legal rights of the Palestinian people, but provisions which are not compatible with these rights, such as those permitting the Israeli occupation and the Trump trusteeship, are void. Likewise, the UN Security Council has not legalized the trusteeship. It doesn't have the legal power to act contrary to that UN Charter imperative I mentioned, that any adjustment or settlement of disputes must be done in conformity with the principles of justice and international law. As the trusteeship is not in conformity with the peremptory legal rule of self-determination, in purporting to authorize the trusteeship, the Council is acting beyond its lawful powers, ultra vires. As such, the authorization is void. This is the same problem the Palestinian people faced a century ago, when, as I indicated earlier, the Council of the League of Nations, roughly speaking the equivalent to the Security Council of the UN, acted ultra vires in purporting to bypass the League Covenant requirement of provisional Palestinian statehood to give the UK the legal authority to retain control as a trustee to implement the Balfour Declaration. Just as then, trusteeship is back in Palestine, and again with a British character to it in the form of Tony Blair. So too, again, the executive organ of the global organization is attempting to legalize this by acting beyond the lawful limits of its constituent instrument. Illegal then, illegal now. Just as with the UK a century ago, states and international organizations participating in this trusteeship now have no valid legal authority to do so, and will therefore be themselves violating the peremptory norm of self-determination. This is the latest turn, then, in what has been a violation of Palestinian rights by a number of states, not just Israel. As I argued last year before the ICJ, the court agreed, and the General Assembly endorsed, all states have important duties to suppress Israel's violations of fundamental rules of international law, duties which would equally apply to such violations perpetrated by other states. A positive obligation to bring the violations to an end, and negative obligations not to recognize them as valid and not to aid or assist them. Here, international law provides a means of enforcement. But many states are failing to comply with these obligations, willing to affirm them in ICJ submissions and General Assembly votes, not so willing to implement them in practice. The Hague Group of States pledged to take concrete action in that emergency Bogota meeting earlier this year mentioned by Izzat, where I had the privilege to act as legal advisor to one of their number, Bolivia. But they constitute only 7% of the world's states, and their pledge only covers a subset of the full suite of relevant obligations. In the face of this current dire situation, and in the light of other horrors in the world, some have said that international law is dead, or at least on life support. In response, international lawyers usually make three arguments. First, although high-profile situations like Palestine are the focus of attention, actually looking across the board to all states and all including day-to-day situations, then, to quote US international lawyer Lou Hankin, most states comply with most of international law most of the time. Incidents of non-compliance should not then be taken to mean that the law does not exist. They're evidence that the law, which exists, is not being complied with. Second, international lawyers argue that certainly when it comes to the principal violators of international law here, Israel and the US and other supportive states like the UK, these represent a minority of the world states. The global majority is against these violations and in favor of upholding the law being violated. These rules of international law being violated exist then because the majority of the world states say so. Third, when it comes to double standards, for example, contrasting approaches to illegality as between Russia's use of force in Ukraine in recent years and Israel's use of force in the OPT since 1967, international lawyers insist that this can enable a form of imminent critique. States' own expressed commitment to rules in one area can be invoked against them in another like context. The invocation of one or more of these three arguments is then the basis to push for greater compliance. For the first argument, violator states are reminded that they do usually comply and so need to remedy any deviations from this normal behavior given the commitment to the law evident in the compliance. For the second argument, it's pointed out to violator states that most states are in favor of the rules they're violating, and they should, therefore, bend to the global majority will and stop being pariahs. For the third argument, hypocrisy is called out. Shaming states for double standards will lead to compliance. These efforts are animated by the belief that the current situation we have is better than nothing and a start from which can be built a more comprehensive universal system. Pushing for compliance is, therefore, a productive use of limited time, resources, and effort. Where does this belief come from? To have a rational basis, it has to assume that the seeds of expansion exist in current developments, that progress is possible within the global system of law and institutions. But is it? We have to reckon with the alternative account of the international system, which would be offered by, for example, realist international relations theorists who see power as the ultimate force in global relations. Here, states' behavior is determined by political preferences mediated by abilities based on material capacities and power relative to other states. So, for the first argument, most states comply with most of international law most of the time, the realist would say, yes, powerful states often comply, but this is because it suits them. Then they don't comply when it doesn't, and they can get away with it. Likewise, other states comply with the suppression duties if they want, and, if so, can withstand the pressure not to by the US and other states supportive of Israel. Current levels of compliance, then, tell us nothing positive about the likelihood of greater compliance conducted in circumstances when it cuts against preferences and/or power pressures. For the second argument, violating states should bend to the will of the global majority, the realist would point out that it's easy for states who are not themselves violating the rules of international law and are unlikely to, for example, the rules on the use of force, which of their nature are only going to be violated by militarily powerful states, it's easy for these states to take robust positions. They would, wouldn't they? The fact they do this tells us nothing about whether states who would have their own behavior constrained would be willing to comply with such constraints. For the third argument, double standards, the realist reminds us that hypocrisy is a core feature of human behavior and, therefore, has to be understood not as a bug, but as a feature of global diplomacy. Calling states out for it, therefore, is not a politically effective strategy when it comes to changing behavior. In the light of these challenges, we have to ask whether we really should accept what international lawyers say, which is to insist, despite the realities staring us in the face, that we adopt a faux naive position, taking what states say at face value. Virtue signaling is when someone makes a public declaration affirming a particular normative position, not requiring any material alteration in their own behavior, and indeed where the making of the declaration is an alternative to taking concrete action. I offer the term international law virtue signaling to potentially explain sometimes the role that invocations of international law can play in diplomacy. In all of this, it's necessary to remind ourselves what this thing is that we call international law and how it is enforced. There is no global sovereign making and enforcing international law. The law is made, somewhat paradoxically, by the very actors, states, to whom it applies. And enforcement is largely a matter of self-enforcement linked to the idea of reciprocity. It is in states' self-interest to comply with the law because they benefit from others doing the same. This presupposes the fiction that all states are equal. As they are, in fact, not equal, there's no reason why the most powerful states must comply with their obligations, at least as far as their relations with less powerful states are concerned, as they can secure the benefits they'd get from having other states comply with their obligations through other means, power. They can have their cake and eat it. Others have to do what the law requires. They can comply only when it suits them or when they're dealing with a peer state. The only other binding mechanism in international law is through United Nations Security Council resolutions, assuming the Council is acting intra vires. But that, of course, is set up to only operate provided that the three most powerful states in the world, and for what it's worth, 2 other states, don't object. So, effectively, excluding those powerful states and their proxies from ever being subject to enforcement action against their will. This is critiqued as unjust, as undemocratic, unlike the General Assembly, where every one of the 193 UN member states has an equal vote. In consequence, the Council should be reformed and or bypassed, if necessary, through General Assembly action. Hence the recent discussions about possibly adopting a Uniting for Peace resolution in the General Assembly to authorize a protective presence in Gaza. But enshrining aristocratic privileges in the P5 was adopted to ensure that the most powerful states in the world at that time, 1945, would be part of the system. If they had this power, and their own actions and global spheres of influence were exempted from effective coverage. This was to avoid what happened with the League of Nations, which adopted a more egalitarian system of governance and, as a result, was faced with a situation where the US never joined and other powerful states left. And to harness their power to the system for enforcement in circumstances where they could agree, as they did, as it turned out very briefly, at the end of the global war when the UN was created. Necessarily then, the system cannot work and is not supposed to work when they can't agree. One only needs to imagine the idea of a protective force being somehow created by the General Assembly in opposition to the USA, which would therefore have to fight Israel and the US into Gaza, to see how General Assembly enforcement action in opposition to one or more permanent members of the Security Council only works as an idea if one somehow discounts the material realities of power. The challenge here, then, is the challenge of unequal power in the material world. The international system of law and institutions reflects it and enables it to operate. But it would exist without the system. And so the system cannot be set up as if somehow it does not exist. Otherwise, it would be the League of Nations. This is why the enforcement of international criminal law through universal jurisdiction nationally and the ICC has long precipitated such an exceptional response from powerful states, because this jurisdiction potentially operates universally and automatically vis-à-vis leaders of powerful and less powerful states alike. Powerful states can and do pressure other states to ensure their national systems don't exercise universal jurisdiction, as part of the usual conduct of diplomatic relations. But the International Criminal Court is not part of this diplomatic system, and so outside of its mechanisms of pressure. Hence, we see the extraordinary measures taken by the US against the International Criminal Court concerning its exercise of jurisdiction with respect to the situation in Palestine. Such drastic action is nothing new. Over 2 decades ago, when the ICC came into being, the US Congress passed the American Service Members Protection Act, informally referred to as the Hague Invasion Act. And the US State Department launched diplomatic efforts to get states parties to the ICC statute to agree that they would never surrender US nationals to the court. James Crawford, who of course drafted the Rome Statute, and myself wrote an expert legal opinion for a human rights NGO in the US, explaining why the agreements were unlawful. Plus ça change, plus c'est la même chose. Now, of course, we have the sanctions by the Trump administration, all explained in terms of the ICC in particular, against 3 Palestinian human rights NGOs, Al-Haq, Al-Mizan, and the Palestine Center for Human Rights, PCHR. Some of the ICC judges, the ICC prosecutor, and the United Nations Special Rapporteur on Human Rights in the OPT. It's instructive to compare this extreme, unprecedented action to the responses to the ICJ advisory opinion last year, which on the subject of Palestine was much more wide-ranging in what it addressed when it comes to the illegality by Israel, compared to what the ICC has done and might do. Last year, Israel didn't even participate in the oral hearing, preferring instead to have its arguments made by proxies. The opinion was dismissed, but no sanctions were taken against the ICJ or its individual judges. Likewise, with the genocide case brought by South Africa, although Israel has turned up to respond to the charges, and various other steps have been taken, again, the ICJ and its judges have not been sanctioned. This contrasting treatment of the 2 Hague courts is perhaps telling us about the interface between power and international law enforcement. Ultimately, the ICJ can be ignored, since the only associated enforcement mechanism, the Security Council, will never be activated because of the US veto. But the ICC, which can lead to enforcement against individuals, or at least drastically restrict their travel options, must be taken seriously. We have to ask whether it's realistic to expect these arrangements to be able to withstand such attacks, given that la raison d'être is, by design, at odds with the nature of the geopolitical system. What current events are, I think, telling us is that we have to be very modest in our expectations of international law. Commitments can be taken at face value when they map on to the power and politics matrix. But when they don't, we have to be honest about their limited value. International law can sometimes be a powerful means of making political arguments in the international arena. It can be valuable in that sense, in a political sense, insofar as the substantive content of the legal rule is understood to have political legitimacy. So, for example, that rule I mentioned, that agreements procured through the use of force are invalid, encapsulates a very important general political idea that when a person has a gun to their head, the idea that they are giving their agreement in any meaningful sense is a lie. But the case for the global acceptance, implementation, and enforcement of moral and ethical imperatives like that one ultimately needs to be made in the realm of politics and power, and through direct action in the material world, not simply through statements, legal submissions, and indeed lectures. Thank you.